All right, so I will be talking a bit about where historically we've been with medical assistance in dying and the current legislation that's come in. I apologize in advance that some of these might have a lot of words and that this might not be, for certain parts, the most interesting, but it helps frame the discussion for going forward on what Shiraz and Robert will have to offer. So historically, the criminal code has made it a criminal offense to assist someone in dying. And I've put the sections up there in case you've brought your criminal code books with you and want to look it up. So back in 1993, the Supreme Court of Canada did consider this decision. Sue Rodriguez suffered from ALS and was seeking approval to have a physician-assisted death. At that time, the Supreme Court of Canada said no. They held that the criminal prohibition on physician-assisted death did not violate the Charter. Section 7 is the right to life, liberty, and security of the person. And then some 22 years later, we get to just last year, which is the Carter decision, where the Supreme Court of Canada again had the chance to consider this question of medical assistance in dying. And so it's called the Carter decision after Kay Carter. She had spinal stenosis, and her family assisted her to go to Switzerland to have a medical assistance in dying. And there was also another plaintiff in this decision, Gloria Taylor, who also had ALS similar to Ms. Rodriguez. So the two decisions were very similar, but this time the Supreme Court of Canada had said that criminal prohibition on physician-assisted death did violate a person's right to life, liberty, and security of the person. But they did qualify it. They have made a very narrow exception for when you may access medical assistance in dying. And so the kind of safeguards that they have put on it, they've made the definition is it's a competent adult who clearly consents to the termination of life and has a grievous and irremediable medical condition, which includes an illness, a disease, or a disability that causes enduring suffering that is intolerable to that individual in the circumstances of his or her condition. And so I put this slide in because the Carter decision does not directly address the issues of mature minors or advanced medical directives. It does limit its decision to competent adults, but as you'll see in contrast to the new legislation, it doesn't completely shut the door on those concepts. The Carter decision had left that more open, whereas the new legislation kind of forestalls that. And so I put this slide in just because there's going to be a lot of talk of what constitutes a competent adult. And so in law, to have the ability to have capacity, and I frame this more in terms of medical treatment, is if someone has the ability to understand the nature and purpose of a proposed treatment and the ability to appreciate the reasonably foreseeable consequences of that treatment, then they're considered capable to make that treatment decision. So we often see this in withdrawing and care at the end of life, or in this setting for medical assistance in dying, a competent person would have to be able to appreciate the foreseeable consequence of what medical assistance in death would be, which would be the termination of their life. Generally in law, there is a presumption that a person is capable to make decisions with respect to medical treatment, unless there are grounds to believe otherwise. In Ontario, physicians do determine capacity, and there's also the Consent and Capacity Board if there are disputes about whether a person is capable or incapable. And then to have consent, it must be informed, which means the patient must have been advised of all the risks and benefits of the treatment and the alternatives to that treatment. So in the context of physician-assisted death, that would mostly revolve around being fully informed as to the different palliative care options, as well as the option of medical assisted dying. So the current legislation, as you are likely aware, came in recently this year. And so it does provide an exception to that criminal prosecution. So it allows medical or nurse practitioners and persons aiding those from being exempt from an offense, so they wouldn't be charged criminally. And so what the current legislation has done in their attempt to kind of codify what Carter has suggested, though I would note at the end that not all of us agree that they did that completely. To be eligible, you have to be eligible for health services by a government in Canada, 18 years old of age, and capable of making decisions with respect to your health. You must have a grievous and irremediable medical condition. You must make a voluntary request for medical assistance in dying that was not made as a result of external pressure. And you must be able to give informed consent after being informed of the means available to relieve suffering. So that's after being informed of your different options, including palliative care. And so then where a lot of the issues people that kind of come in, the differences between the Carter decision and the new current legislation can be mostly seen here on this slide when they define what grievous and irremediable means. In the legislation now, it says it's a serious and incurable illness, disease, or disability in an advanced state of irreversible decline in capability, that the illness, disease, or disability, or the state of decline, is causing the patient physical and psychological suffering that is intolerable to them and cannot be relieved under conditions that they consider acceptable. And what that's really saying is that you don't have to try every palliative treatment available to you if it's intolerable in your current condition. Also that natural death has become reasonably foreseeable, taking into account all of the medical circumstances without a prognosis necessarily having been made. So they have not put a time frame on it, but as you'll see, there's also no definition of what reasonably foreseeable means, which is causing, I imagine, we'll hear from our other panelists some consternation and difficulties in practicality. And I'm just briefly did the procedure. I know that Robert will be going into practically how this plays out, but this is pulled from the legislation itself, so it's a bit wordy. So to meet that definition or to access medical assistance in dying, a medical practitioner must be of opinion that you meet all the criteria, and then you must have made your request in writing. It must be signed and dated. It must be signed and dated after you've been informed that you have a grievous and irremediable medical condition. They must be satisfied that it was signed and dated by the actual person and that 2 independent witnesses have also signed and dated it. An independent witness is essentially somebody who is not a beneficiary under the will or will not benefit from the death of the patient requesting medical assistance in death. The medical practitioner needs to ensure that the person has been informed that they can at any time in any way withdraw the request. And another medical practitioner who is independent has to provide a written opinion confirming also that they are of the opinion that the person meets all the criteria. And so again, independent in this case is the physician can't be the supervisor of the first physician. They can't be a beneficiary or believe that they're a beneficiary under the will of the patient. And they must generally think that they can be objective, so that they're not too close to either the first physician who made the assessment or the patient themselves. And then there must be 10 clear days between the day on which the request was made and the day on which the medical assistance is ultimately provided. And then finally, immediately before the medical assistance is provided, the patient must be given an opportunity to withdraw their request, and they must give express consent to receive the medical assistance. And so then I've kind of highlighted already, and I'm sure that a lot of questions may arise from this, but generally speaking, the main differences between the Carter decision and the current legislation is that the current legislation adds 2 additional requirements to the definition of grievous and irremediable harm. So 1, that the patient is in advanced stage of irreversible decline in capability, and 2, that their death has become, natural death has become reasonably foreseeable. And so we don't see that those restrictions in the Carter decision. And so this kind of limits the field of who could potentially access medical assistance in dying. So as it stands now, the current legislation would not apply to somebody who is not near death. So for example, a patient who could be suffering intolerably and could be competent, but they might not be going to die for another 15 or 20 years, and instead of being able to access this as they could under the Carter decision, they will have to suffer for those 15 or 20 years until their natural death becomes reasonably foreseeable. They've also Both the Carter decision and the current legislation have the concept of a competent adult. The legislation specifically says 18. And so I've put here that neither allow for mature minors or advanced directives, but in Carter it doesn't specifically exclude it, and there are different concepts in the legislation where people who are under 18 are capable of giving consent. And of course, the Substitute Decision Makers Act, you can make advanced directives for withdrawing other end-of-life care. But so based on Carter, it was open to make those arguments and those interpretations. We didn't see how the court would rule because this new legislation has come in and just kind of put a stop to that. There is a provision that within 180 days of when it came into force, so if that was June, hopefully, I guess that would be around December, they're supposed to have an independent review, one or more of each mature minors, advanced directives, and a primarily mental disabilities. So they're supposed to be doing independent reviews with respect to those areas. And finally, there is at least one constitutional challenge. The British Columbia Civil Liberties Association has launched a constitutional challenge to this legislation in relation to those two eligibility requirements that I had mentioned, the requirement for an advanced state of irreversible decline and for the natural death, which is reasonably foreseeable. And that's all for me.